matter of Alame, others, Shell Plc, and another.
Who is going to start?
Well, in the light of that, I will stand up simply to say that Mr. Willen will start.
Right.
My Lord, I apologise. In terms of housekeeping, the first appeal is the limitation appeal, which I will be addressing. That's scheduled to take the first day and a half. I'm down to open it for 3 hours and reply for an hour. I suspect I'll be slightly longer opening it, slightly less in reply, but we'll stay within the 4 hours allocated to me.
If there is a timetable that you've agreed to between you, I, for one, haven't seen it written down, but not that we'll be bound by it, but tell us what it is.
There is. I can hand up a copy if that's helpful, but it is... I can hand up one copy in any event, but in short, it is... The first appeal, the limitation appeal, is the first day and a half, and then the other appeal is the second, the half day, and then the following 2 days. I'll get some more copies of that so that you have a copy each. But that, I believe, was submitted in response to a request by my Lord Justice Stuart-Smith.
I'll take your word for it.
Yes, the only thing I would say by way of comment is that, of course, cases often expand to fill the time available, but we very much hope that we will not be up against the buffers at 29 minutes past 4 on Friday.
Yes.
Because apart from anything else, it would be of enormous assistance to us if we had some time on Friday after the hearing is finished to discuss the case before we're all dispersed into different constitutions. And in any event, we rather think that by the time we've had 1.5 days on the first appeal and some time on the second appeal, we'll all be much more into the rhythm of the case.
My Lord, yes.
All right. Do we all have copies of this somewhere?
I'll ask for copies to be provided. It's not.
Yes,
I don't think it's made its way into the bundles, but I will make sure you have copies during the morning.
All right.
So, my Lords, I won't say much by way of the background. You know these cases are about environmental damage allegedly caused by 2 oil spills in the Niger Delta. That's the Bille and the Alame communities. This appeal is essentially about which spills, and the second appeal is about how those spills allegedly caused loss. Both of the appeals arise out of essentially the claimant's pleadings, and more precisely what we say is a failure by the claimants to have pleaded the essential facts on which they now say their claims are based. So this appeal concerns 2 sets of amendments by which we submit the claimants sought to significantly expand the scope of these proceedings. The first of those sets of amendments, which is ground 1 of the appeal, has been referred to as additional spills. That's only relevant to the Bille proceedings, both the Bille Individual and the Bille community claims. And we submit that the effect of those amendments was to extend the claim from one which pleaded the essential facts of 10 spills to one which pleaded the essential facts of 95 spills. The second set of amendments have been referred to as the illegal refining amendments, and they apply across the board, so to both the Bille and Alame community and individual proceedings, all 4 sets. And those amendments seek to extend the claim not just to oil spilled from the pipelines operated by the second defendant, SPDC, which was the original basis for the claim, but to hold the defendants responsible from oil that was discharged from illegal refineries to the extent that they were refining oil stolen from SPDC-operated pipelines. And those amendments, as I say, are the subject of ground 2. It's common ground that to the extent those amendments did introduce new claims, those claims would at least arguably be time-barred. That's because on our case, all claims are subject to a 5-year limitation period under Nigerian law, and the amendments were made 10 years or more after the relevant events in Bille, and potentially 30 years or more after the relevant events in Alame. Now, the judge concluded that in neither set of amendments had introduced any new claim, any new cause of action, and therefore, in her judgment, CPR Rule 17.4 was not engaged at all. Our overarching criticism, which I will develop, is that the judge erred in coming to that conclusion because she looked at the case too broadly. She asked did the parties contemplate, what was the case about, and that is not, in our submission, the right question. The right question is what essential facts had been pleaded in the particulars of claim before they were amended. Now, the judge also concluded, in respect of the illegal refining amendments, but only the illegal refining amendments, that even if those amendments did introduce new claims, they would fall within the exception in Rule 17.4 for claims arising out of the same or substantially the same facts. And again, we make essentially the same criticism of the judge, that she failed to analyse with sufficient specificity what facts were actually in issue on the original pleadings, and therefore erred in finding that there were no new facts arising out of the illegal refining amendments. Now, the same point, the 17.4 exception, if I can call it that way, is raised by a respondent's notice in relation to the additional spills amendments, but that's not a conclusion the judge reached. It's an alternative ground for upholding the judge's order raised by the respondents in their respondent's notice. The final point, just in terms of setting out the landscape of the appeals, is that my learned friends have raised by their respondent's notice an argument that even if these amendments did not fall within the scope of 17.4, so they were new claims and they don't arise out of the same or substantially the same facts, they say that the court could nonetheless allow them on what's come to be known as the MasterCard basis, which is essentially that the court orders that relation back is disapplied, or more precisely, that relation back only applies to a particular date, rather than to when the claim form was originally issued. I'll deal with that at the end of the submissions, but our short answer to it is that the MasterCard basis is not one available to the court.
We don't have the power to follow it?
You don't have the power to follow it.
Because?
Because Rule 17.4 says that the court can only permit the amendments where a limitation period has expired, only if the conditions in that rule are satisfied. And therefore, if the conditions in that rule aren't satisfied, the court simply doesn't have the power to grant the amendment.
So MasterCard's wrong?
Well, MasterCard was not, the point wasn't argued. In MasterCard, the only point that was argued, the parties having agreed that it could be done, was what was the appropriate date.
There is a decision, I think, of Lord Justice Rupert Jackson addressing 17.4, where he says in very clear terms, if you've got a potential limitation problem, you should issue new proceedings immediately. Have we got that in the authorities?
I'm not sure that is in the authorities bundle. There are authorities to that effect, and equally there are authorities that say there are only two options.
Yep.
Either the amendments are allowed or they're refused. But in a sense, I don't try and take advantage of those because, again, the point wasn't argued. It wasn't being suggested that there was an option to the court to order relief on the MasterCard basis. There are certain, we'll make sure we find that authority and bring it. There are some first instance authorities that have looked at this. There's a decision of Mr. Terhar as a deputy and a decision of Mr. Justice Fancourt, both at first instance.
But there is a decision of this court in a judgment last week called Viegas and Cutrale, where MasterCard was not cited, but a similar sort of solution was reached as a result of acceptance of an undertaking. I don't know whether that has any bearing or similarity to what we have to decide, but I mention it so that you can have a look if you haven't already seen it.
And my lord, ultimately, when I get to this point, the short answer, or our short answer will be, if the parties don't, our position is that if the parties don't agree, then the court's power is circumscribed by Rule 17.4. And we say, in fact, that the Welsh Development Agency is binding authority to that effect. And I will show your lordships that in due course.
So at a very early stage, the first two cases to be mentioned by anybody are not among the 88 authorities in the bundles it was sent with us.
No, my lord. I hope that is for the good reason, ultimately, that in a sense they don't actually grapple with the point in that they are cases where the solution was arrived at by, certainly the case that my Lord Justice Mayles refers to was arrived at by consent. And I accept there are a number of cases, MasterCard being an example, where the solution was arrived at by consent of the parties. The question really is, well, what if the parties don't agree? What are the court's powers?
Right. Okay.
What I was proposing to do with that introduction is then briefly set out the legal framework under 17.4, which is largely uncontroversial, and then deal with the two sets of amendments, so additional spills and a legal refining in turn, before finishing with that MasterCard point. Now, because it's conceded that if the amendments introduce new claims, they are arguably time barred, Rule 17.4 is engaged, or potentially engaged. And, my lord, you have that in Authorities Bundle 7, tab 70.
Page?
2850. And that rule, which I'm sure is familiar to the court, applies where a period of limitation has expired. And of course, the authorities make clear that if there's an arguable case as to whether a limitation period has expired, one has to proceed under this rule. And sub-rule 2 provides that the court may allow an amendment whose effect will be to add or substitute a new claim, but only if the new claim arises out of the same facts or substantially the same facts that are already an issue on a claim in respect of which the party applying for permission has already claimed a remedy in the proceedings. That rule gives effect to Section 35 of the Limitation Act, which is in the next tab, page 2852. And the way that Section 35 works is that subparagraph 1 deems new claims to have been commenced under subparagraph B on the same date as the original action. So you have statutory relation back. And I just pause to say, for when we come to MasterCard, that is a mandatory provision. It's not something that operates in the court's discretion or requires an order. It is simply a statutory provision as to what effect an amendment has. And then linked to that, Rule 35.3 effectively prohibits the court permitting an amendment save as provided by Section 33, which is disapplication in certain cases of personal injury or death, or by rules of court, which is 17.4. That section prevents an amendment being allowed, which after the expiry of a time limit to which the Act applies. And then the relevant rule, 17.4, has then been made under subparagraph 4, which permits new claims to be introduced in those limited circumstances. Now, I should just make clear, just to avoid any possibility of misleading anyone, that Section 35 is not strictly an issue on this appeal, because we are dealing with a foreign limitation period. And there's been a certain amount of law as to how one gets to the point that relation back does apply to foreign limitation periods. But we've both, I don't think there's any dispute about this, relation back does apply to amendments made in this case, even though they're governed by a foreign limitation period. Now, it's important to say, therefore, that when the judge was...
there might be, I suppose, a difference, because you just made the point that it is Section 35 which says that relation back applies, and that's an end of it. Does one have to look to see whether the comparable foreign legislation is to the same effect?
So the way that the English court has got to this point is to say that under Rule 17.4, if you go back to tab 70, page 2850, under 17.4, 1b Roman 3, any other enactment which allows such an amendment, it is to treat the Rome 2 regulation, which is the choice of law rule, as being an enactment under which an amendment can be made, and therefore to apply 17.4 to such amendments. And then to say that because 17.4 proceeds on the premise that there must be relation back, therefore relation back applies, even though Section 35 doesn't. And there's a decision of Mr. Justice Saini in Qatar Airways to that effect. So one gets to the conclusion that Section 35 applies by analogy because it's a necessary implication of having Rule 17.4. And it's not a question for the foreign law. There's been a certain amount of debate in getting there, but that's the position that has been reached. Now, it's important to say that because of the terms of Rule 17.4, the judge was not exercising any discretion in deciding whether Rule 17.4 applied, was there a new claim, and did it arise out of the same or substantially the same facts. She was making substantive judgments. And that's a point made by Lord Justice Sales in the MasterCard case, that Rule 17.4 gives rise to substantive questions of law and important ones, and not matters of discretion for the judge. And important ones, because of course the effect, if we are right, of allowing an amendment is to revive a cause of action which the legislature, here the Nigerian legislature, has provided cannot be pursued. It is barred by the effluxion of time. And therefore, one is reviving what is otherwise a barred, statute-barred claim. And that should only be done if the conditions of Rule 17.4 are precisely satisfied.
Does 17.4 mean that you have to look at two points once you've decided it's a new claim? One being whether it arises out of the same facts as are already an issue, and the other being whether the party applying for permission has already claimed a remedy in respect of those facts. So if we apply that, for example, to the dumping of crude oil by illegal refiners, one might say, well, those facts do seem to be already an issue because there's an awful lot in the pleadings about that. But we also have to look to see whether the party applying for permission, i.e. the claimants, have claimed a remedy in respect of such dumping.
That must be right, my lord. That's the effect of the statute, of the rule as written. So one has to look at whether the claim is one in which a remedy is being sought. I think that must be
rather
right.
Against the analysis in some of the authorities that if the defendant raises a factual defence, the claimant can say, oh, well, you're liable in that event, even so. Because they haven't said that before.
I think
cases seem to say they're allowed to do that.
they certainly are, and part of that is an Article 6 compliant reading of the rule. So and that's the Good and Martin point, that it wouldn't be consistent with Article 6 to say that a defendant could defend, but then the claimant couldn't rely on the same scenario to turn that back on the defendant. But my lord, it's nonetheless that the proper analysis, I think, has to be, one looks at what are the claims in respect of which remedies are currently claimed. Because the question is, what facts are already an issue on a claim in respect of which a party applying for permission has already claimed a remedy. So one is looking for claims in respect of which a remedy has been claimed, and then asking what facts are in issue on that claim. And so it may well be that matters raised by the defence are in issue on that claim, not because they're relied upon to support the claim, but that they are in issue because they are being raised in defence to the claim, and therefore they are in issue on the claim. And I accept that that is how Rule 17.4 has been interpreted, that in issue on the claim doesn't mean matters raised by the claimant to support its claim. It means facts that are in issue will have to be decided potentially by the court in resolving the claim that has been made. And that has to be a claim in respect of which a remedy has been sought. In terms of how 17.4 works, both my learned friends and I have relied on the Geo Minerals case, which is in Authorities Bundle 3, tab 20, page 958. In which my Lord Justice Mayles gave the judgment. And it's convenient to use this as a summary of the principles that are to be applied.
I don't think I was conscious of saying anything new.
No, and indeed, my Lord is quoting largely Mr. Morris in Diamandis, who himself is quoting other authorities, but it nonetheless is quite a helpful authority in bringing together the principles that apply and essentially uncontroversial between my learned friend and I. The case itself doesn't really, certainly the facts of the case don't really assist, because my Lord's view at the end of it was that the amendments were pretty trivial and therefore they didn't engage the principles in any event.
Have you cited this in your skeleton argument?
Yes.
I think you have. I mean, if the context isn't necessary, it might be helpful at least to have the reference to your skeleton argument.
Yes, I can certainly do that. So it's in Core Bundle 1, tab 7,
Page 103.
page 10. Sorry, my Lord, I missed that.
In my bundle, it's page 103, paragraph
103.
18.
Thank you very much, Liz. It's the bottom of page 103. So that's summarising the four-stage test. And that you get from paragraph 25 of the authority. Relevant principles, four-stage test. Is it reasonably arguable that the opposed amendments are outside the limitation period? Common ground that the answer in this case is yes. Stage 2, did the proposed amendment seek to add or substitute a new cause of action? That is an issue here. Third stage, does the new cause of action arise out of the same or substantially the same facts as are already an issue in the existing claim? Third stage, that's an issue here. And then the fourth stage, should the court exercise its discretion? Not an issue, because we don't challenge the judge's decision that if she had power to allow the amendments, she would do so as a matter of her discretion.
I think the case I mentioned from last week, Villegas and Cutrale, adds, or at least clarifies, a fifth question, which is whether the defendant would be prejudiced by the operation of relation back, but presumably that doesn't arise as a point.
It doesn't arise here. No, there are some cases where, and Welsh Development Agency refers to this, the limitation period must either have expired before the original claim form or sometime after the amendment, in which case the 17.4 doesn't matter because relation back isn't going to have any impact, but that's not a point that arises here. Paragraph 27 then deals with the principles to be applied at the second stage, which is identifying whether there is a new cause of action. What we would say is that if one looks at subparagraphs 1, 3 and 4 there, is that in seeking to identify a cause of action or a claim, one is looking for the bare minimum legal fact or bare minimum facts that need to be pleaded to establish a legal right. And you see that in particular subparagraph 4. And then it tells you it's the bare minimum of essential facts. And subparagraph 3 tells you it's every fact which is material to enable the claimant to succeed. And so it follows that when you are deciding whether there is a new claim, what the court is doing is comparing the bare minimum essential facts to support the original pleading with the bare minimum essential facts to support the new pleading or the claims in the new pleading. And then paragraph 2 tells you that when you've done that comparison, when you've compared the unamended and the amended pleading, you're looking to determine whether a different duty is pleaded, whether the breaches pleaded differ substantially, and where appropriate, whether the nature and extent of the damage of which complaint is made. And then this, where it's the same duty but a new breach, new or different loss will not be a new cause of action, but where it's a different duty or a different breach, then it is likely to be a new cause of action. So new breach or new duty, likely to be a new cause of action.
Where were you reading from just then?
Sorry, that's subparagraph, in paragraph 27, subparagraph 2.
Yes, thank you.
And it's the parenthetical phrase at the end of that.
Yep, got it.
And just while looking at subparagraph 2, in the third line of that, you'll see there's reference to a comparison of the unamended and amended pleading. Now, we say that that must be simply the particulars of claim. Because at this stage, what you're looking at is whether the amendments introduce a new claim. The only place you can find a claim is the particulars of claim. The defence can't introduce a claim, self-evidently, and the reply is not permitted to introduce a claim. Practice Direction 16, para 9.2, says that a reply must not bring in a new claim. So the only place you can find claims is in the particulars of claim. And I suspect that won't be controversial, but if it is, that point was touched on in Mullally, where the first instance judge, Mr. Justice Pepperell, said you can't bring in new claims in a reply for a whole host of reasons. Contrary to the rules, it would produce unfairness because there'd be no opportunity to reply to them and so forth. And that was not challenged before the Court of Appeal. When you're doing this comparison at stage 2 between the amended and the unamended pleading, you're looking simply at the particulars of claim. Different when you get to stage 3, when you do look at matters raised by the defence. At stage 2, what are the claims? You are looking at the particulars of claim.
And any further particulars provided of the particulars of claim?
My Lord, I'd say no, in that the only way the only way, proper way, that a new claim could be introduced would be by way of amendment. You couldn't do it by way of further information.
If you did have something which looks suspiciously like a new cause of action emerging in the course of further information, which is not unheard of, the defendant's remedy is to say, this is a new cause of action, you've got to amend.
Yes.
But if the defendant doesn't do that, the court can't be precluded from looking at what has already been pleaded as the claimant's claim. So we're not talking about reply. We're talking about the material that has already been pleaded in one document or another. Call it a schedule, call it a this, call it a further information, whatever.
My Lord, my submission would certainly be that the document one looks at to identify the claims is the particulars of claim.
Well, that's where you start.
If anything further is provided later, that can't introduce a new claim. It can only particularise what is already claimed. And if it purports to do so, it's ineffective. One can't simply serve voluntary particulars of claim and say, oh, well, now you've got to strike them out.
People do it all the time.
But people do it, but the question is it effective? That when then one comes to amend, I mean, take for instance, could one serve voluntary particulars of claim, then seek to amend the particulars to bring them in and say, oh, well, they're already an issue because I served voluntary particulars 10 years after I started the claim? And the answer to that must be no, because that would be a straightforward circumvention of...
Well, your answer would be you must amend, and you can't amend because you're within 17.4.
Yes, but and then it comes to the same thing, I'd suggest, my Lord, that if the court says, well, it shouldn't have been there, and you can't bring it in, then the fact it was there hasn't made any difference to the analysis.
Maybe.
But the difficulty is otherwise, one's sidestepping Rule 17.4 and the restrictions on the court's jurisdiction under Section 35.
Many times it doesn't matter. Sorry
Yes.
to take your time on this, but many times it doesn't matter because limitation doesn't arise. And so, for example, if someone does particulars of claim, there's a very prompt request for further information, and the further information arguably amplifies or gives rise to a new cause of action. No one's going to be bothered if it hasn't impacted on
No.
limitation. But if it has impacted on limitation, then the defendant's remedy is not just to ignore it, but to say, you can't do this, you must apply for leave to amend 17.4.
Well, my Lord, I would accept that that's something that could be done, but if it came into issue on an amendment application, say the defendant hadn't proactively done anything, the further information had come in, and then an application is made proactively or voluntarily, let's say, by the claimant to bring it into their particulars of claim, in my submission, there'd be nothing to stop the defendant saying, well, you can't do that because it's prohibited by Rule 17.4, and the mere fact you tried to do it in an impermissible manner doesn't give you a leg up or an advantage because there's no power to do it. You can't introduce a claim in that way. And the point now having been taken, the court can't allow voluntary particulars to do something that they're not empowered to do. Otherwise, one would have the problem that one sees in this case. It is we have the claim, particulars claim, we have the defence saying this isn't properly particularised. We then have a reply which arguably seeks to bring in unpublished spills, and then further information referring to the reply as an attempt to basically shoehorn the reply back into the particulars. And that's simply avoiding the proper operation of pleadings, the proper operation of Section 35. Because the court can't allow that to be done. It can't allow a new claim to be introduced. Paragraph...
What does it mean in stage 3? I know this is quoted in the judgment of mine, but what does it mean to say the selection of material facts must be made at the highest level of abstraction?
My Lord, it's a phrase that has produced some difficulties, and there's one judgment, the name of which now escapes me, where the Court of Appeals says that seems to have led the judge into error in thinking that it's a very abstract exercise, when all it really refers to is the fact that you're looking at the bare, essential, minimum facts. And I'll find that authority for you, but that's what we say. It really is nothing more than a repetition of the fact that one's not getting into the details and the particulars and the evidence that might be served. One is looking very abstractly at what are the bare minimum essential facts that constitute the cause of action. And in that sense, it's abstract rather than concrete, as stage 3 is, looking at the actual evidence and issues that might be raised in practice. And one sees that, if my Lord looked at paragraph 28, subparagraph 4, there's a reference to stage 3 being much less abstract than stage 2, because at stage 3, one is considering the whole range of facts which are likely to be adduced at trial, and that's the comparison with stage 2. where stage 2 one's not looking at the range of facts which are likely to come up at trial, one's looking at the bare minimum essential facts, which as a matter of legal theory constitute the cause of action. My Lord, paragraph 28 then deals with the third stage, which is the same or substantially the same facts. Really just to emphasise a couple of points here. Paragraph 1, or subparagraph 1, the most important, same or substantially the same is not synonymous with similar. We say substantially the same is a very narrow gateway. Subparagraph 3, and I will come back to this a little bit later, this is a quote from a case talking about the purpose of the exception. And there is a case that says the purpose of the exception is to avoid placing the defendant in a position where he's obliged, after expiry of the limitation period, to investigate the facts and obtain evidence of matters completely outside the ambit of and unrelated to the facts, which he could reasonably be assumed to have investigated. That is, and my learned friends try and use that almost as a substitution for the statutory test. It isn't, and there is authority warning that high-level statements of the purpose of Section 35 mustn't be used in substitution for the statutory wording. And we say that's obvious, in part because one cannot equate substantially the same with not completely outside the ambit of and unrelated to. That's not a sensible definition of the phrase substantially the same. Point 5, finally, in considering whether the relevant facts are in the original plead, in considering what the relevant facts are in the original pleading, a material consideration are the factual matters raised in the defence. And that's the Good and Martin point, that for stage 3, you are entitled to look at what facts are raised on the defence, as well as the facts raised in the particulars of claim. So that's the statutory or the rules framework. If I then turn to the additional spills amendments, and what I'm going to do is show your lordships the pleadings, or particularly the particulars of claim, because we say that's where this appeal really begins and ends. Then look at the stage 2 analysis. Did it introduce a new claim? Then look at stage 3. If so, did it arise out of the same or substantially the same facts, which is the respondent's notice point. And as I understand my learned friend's case, which seems to have been accepted by the judge, is that the particulars of claim already cover all spills, identified or unidentified, and so any amendment to identify a spill is therefore just particularisation of what was already there, albeit in an inchoate, unspecified way. And we submit that that analysis is wrong because what it fails to do is to look at what facts were actually pleaded in the particulars of claim.
You didn't apply to strike out the reference to unidentified spills, did you?
We have not applied to strike out the reference to unpublished spills in the reply. We did not apply to strike that out.
So the area that we're looking at, and that you and Mr. A or whoever are concentrating on, is the fact that the original pleading undoubtedly refers to spills other than those that have been identified.
Yes, it reserves the position in relation to other spills.
It reserves the position, but it makes clear that the claimants want to rely upon other spills which they don't yet know about.
Well, my lord, I submit it doesn't go quite that far, although even if it did, I'd say that doesn't matter. But yes, it makes clear what we'd accept is it certainly indicated that it was perhaps even a certainty, a likelihood, that the claimants at some point would want to introduce further spills.
So and that's not been struck out, that's always been their position.
It has.
Which would mean that it would put an enormous premium on delaying the process of disclosure so that they could then find out if there's anything more that they can deal with. I know you say it's a fishing expedition and all that, but I'm just putting it tendentiously for a moment.
Well, I suppose there are a number of answers to that. One of which that these spills are not ones that arise out of disclosure. These are ones that are actually on SPDC's and the regulator's website. So that these amendments actually don't fall into that category. Of course, the answer to that is when my Lord speaks in terms of dragging out disclosure, the court obviously has control over disclosure. If a claimant is saying there is a pressing need for me to get disclosure so that I can, because I think there are more things I need to plead and time is running out, no doubt the court would manage it in that way. Now, in fact, the specific disclosure applications come far, far down the line, long after the replies were submitted, long after CMCs. And so, in a sense, the situation that's arisen is very much of the claimant's own making, but they only actually applied for specific disclosure very late on in the process. But in a sense, stepping back, my Lord, as I say, this is not a case where these spills that are now pleaded are concealed. They are on public websites. If there's a concern that there are more spills which a party would like to plead, there are a number of ways of doing that. The obvious one being disclosure, whether that be pre-action or as soon as a claim has been started. Obviously, in many cases, if someone is concealing facts, limitation won't be a problem anyway, because the limitation period, certainly under English law, is extended for concealment by reference to a statement of claim test. Essentially, could you plead the facts that you now want to, could you have pleaded the facts that you now want to rely on earlier? But if the position is there isn't concealment, there's no basis for extending the limitation period, the claimant hasn't taken the remedies available to them to identify any further claims that they might have, then that's the fact that they can't then bring them later is just just a consequence of how limitation periods are meant to operate. If a party doesn't actually know that it has a claim, it thinks it might, but it doesn't know the facts that it needs to plead that claim until the time bar is expired, that in a sense is what time bars do. Parties may suspect they have claims, but if they're not in a position to plead them within the time given to them, then the effect of the statute is that they can't bring them. Now, by way of an overarching remark in relation to this part of the appeal, we submit, of course, that each spill is its own cause of action. And that's because each spill inevitably turns on its own unique facts. I'll come back to develop that, but it will depend on when and where it occurred, what led to that particular spill occurring, was there relevant negligence, was there third-party interference, and what happened to the oil, where did the oil go, what did it damage. And so each spill turns on its own unique facts, and therefore each spill is a cause of action because the essential facts to establish liability for that spill are unique to that spill. And as I say, I'll deal with that in a bit more detail when one looks at the pleadings. But it follows that in order to succeed on their claim, the claimants need to identify particular spills. That's the essential starting point of any claim, is identifying the spill that they rely upon. And that shouldn't, I think, be a controversial proposition. So I just show you something that my old friend Mr. Hermer said to the claimants, said on behalf of the claimants to Mrs. Justice May. That's Supplemental Bundle 1, tab 12, page 209.
209.
209. And it's internal page 32. This is the July 2023 CMC. And it's lines 5 to 8. And so Mrs. Justice May was attempting to tease out essentially what needed to be identified. And Mr. Holmes says, can I make our position as plain as I can? In order to prove their case, a claimant will need to demonstrate that particular spills for which Shell is legally responsible caused the damage complained of. And we say that is absolutely right. And if the essential facts of their claim include the particular spills complained of, then the essential facts to be pleaded include the particular spills for which the claimants say they can establish liability.
Well, how particular is particular?
Well,
Have to be a date.
with sufficient particularity that the defendant knows what case it has to meet. So I'd accept one is not saying it necessarily has to be a spill at location down to a metre on a particular date. There must be some flexibility, for instance, to infer that there was a spill in a particular month at a particular location. But what it cannot be, because it is not a description of a spill, is there were spills in the Bille region over 3 years. Or even worse, there were spills in the Agale region without limit of time, which is the Agale pleading. Because that's not identifying a spill, that is identifying a general complaint.
Doesn't it depend on facts? I don't want to anticipate the arguments about global claim, but if the only source of oil in the Bille region was Shell, and I appreciate that there may be other operators who've had pipelines, and if the only possible causes of pollution were things for which, under Nigerian law, Shell was responsible, and there's an issue about that, I know, then why would it be necessary to specify particular dates or even particular months when, or places when spillages happened?
In part because the cause of action for each spill depends on how it arose. So, for instance, if it's a pipeline spill, it's liability under the Oil Pipelines Act, which has a statutory compensation scheme. If it's a non-pipeline spill, it's subject to the common law with common law principles of damages. And so one can't simply say, well, it doesn't matter. It's a matter of indifference. What the spill, what the actual source of the claim is, whatever it is, you're liable for it in the same amount. To the contrary, the liability will very much depend on where, and particularly where, the spill occurred. And so it's not, in my submission, and that's why Mr. Hermer in my submission was right, it's not capable of simply being said, and this is not in fact how it's pleaded, whatever spills happened, you must be liable for them in the same amount, and therefore, and there is no other potential sources of oil, therefore we will simply prove our case by saying, if there is any oil in Bille, somehow or other you must be liable for it, and you'll be liable to pay damages in the same amount.
That doesn't answer my Lord's question. I mean, his question was, if Shell was the only source of oil
Yes.
at a particular place in a particular year,
Yes.
then doesn't that tend to show that they are prima facie liable, even if the particular claimant can't say this happened on July the 27th?
Well, but Lord, firstly, I'm just careful about answering the question versus this case. Obviously, in this case, everyone accepts that there are other sources of oil, not least illegal refineries.
Yes.
So the case has never been pleaded as we are not going to try and prove individual spills. We are simply going to say whatever the source of oil, you are liable for it, and irrespective of the source of your legal liability, whether that be common law or statutory, your liability is the same. Therefore, we don't need to identify the spill. That's never been the way the case has been put. And even on global claims, the claimant's case is still, here are the spills, and we rely on those spills as causing the loss. And we say that that's a global link because it's using all the spills to cause all the loss. But it's not saying there is only one potential source of oil in the Bille and Agale regions. That's never been the case that's been pleaded against us, and it is demonstrably not the case. But, my Lord, in my submission, even if one could say that that might demonstrate prima facie that Shell has some legal liability of some form, because wherever it came from, it must be Shell. Nonetheless, where one has different legal sources of liability, statutory and common law, the statutory source, it being common ground, excluding the common law remedies. One has to know, is the oil coming from an asset governed by the OPA, or is it coming from an asset governed by the common law, in order to apply the correct principles both of liability and of quantification of damages, there being a statutory regime for quantification of damages under the OPA, and simply saying, well, you must be liable in some form, because isn't enough. That doesn't plead the essential facts, which give rise to a cause of action. And
that seems very odd to me, and somebody who knows nothing about Nigerian law, but no doubt we'll come to that.
well, my lord, I'll show you the way it's pleaded, because this is a claim pleaded by reference to spills. And in part because there are different causes of action for different types of spills, there are different defences for different types of spills. And I'll show you that when we go through the pleading. But in my submission, that is right, and Mr. Hermel was right to accept that identification of particular spills is essential for the claimants to succeed at trial.
And just adopting the approach, it may result from the same breach of duty as has previously been pleaded, but it's going to be a different breach, leading to different damage subject to delicious questions of causation.
My lord, yes. I mean, just stepping back, to take some hypotheticals, which are not, in a sense, hypothetical. They're the way this claim works. One of them is a spill in 2011 on the east side of Bille due to corrosion from a pipeline. One of them is a spill in 2013 from the west side of Bille from a non-pipeline, so subject to the common law regime, due to a failure to prevent TPI, third-party interference. The facts related to those two spills are completely different. If you're looking at a pipeline spill, you're under the statutory regime. Statutory regime is prima facie strict liability, subject to, we say, a defence for acts of third parties. So you're not going to have any facts relating to liability other than the mere fact there was a spill. Compensation is then going to be governed by the statutory regime. The oil that's come from the east side of Bille will have gone in particular places. It will have flowed in particular ways, depending on the rivers in the east of Bille. It will have harmed particular people who fished perhaps on that side of Bille, and it will have harmed people in 2011 and 2012. That is completely different to the spill in 2013, which requires demonstration of a duty, because it's a common law claim. It requires proof of negligence, so there'll have to be an investigation into what negligence there was. Have to be an investigation into causation. If they'd done something different, would that have stopped the oil being spilled? Would it have reduced the oil being spilled? Where did that oil go? That will depend on the hydrology in the west of Bille. It will have harmed most likely different people who are or fish or live on the west of Bille. And obviously it will have harmed people at different times. 2011 versus 2013, the accrual date for that cause of action will be different. No one's suggesting that all causes of action for spills occur on the first date that any oil was spilled in Bille, and that must mean that there are different causes of action. Otherwise, we'd be entitled to say all harm in Bille becomes time barred, or the causes of action accrue. There's just one cause of action for all spills. Accrued on the first date there was any damage caused by a spill. And that's plainly not the case. Each spill will have its own accrual date because it is its own cause of action.
So is it your position that in respect of each spill which is relied upon, the cause of action needs to identify and there needs to be pleaded not only the date and place where the spill occurred, but also the mechanism by which it occurred, the kind of infrastructure or equipment from which it occurred, and the location of the damage which it caused? And that all of those, you say, are
essential facts of the cause of action.
95 essential
Yes.
points of pleading, which aren't there at the moment.
Is
that your position?
My Lord, it is, yes. Now, I accept that, of course, on some of those, the claimants are entitled to have alternative cases. They can have a case, as they do, that we say that this was operational failure, but if it wasn't, because it was a third-party interference, you're liable anyway because you didn't prevent it. So they're entitled to say, well, actually, you're liable in one of two ways. There's no difficulty with that. And equally, I accept that there is, providing they identify a spill, there will be some, the court will accept some imprecision as to the identification of that spill. Even in many contexts, one allows an on or around pleading of a date, even an oral contract. You've obviously got to plead that it was made, but one doesn't have to tie the date down to the precise date and time. You can say in or around July 2011. But those are essential facts. And of course, if one were pleading, as happens in the vast majority of cases, Bodo, Jala, a single spill or two spills, that is precisely what one does. They say, well, you say, well, here's a spill, it released oil, you're liable because you didn't maintain the facilities or you continued to load when oil was leaking. The oil has travelled to this region and has caused damage. Now, the mere fact that a claimant has decided to lump together claims for 95 different spills, or in Agale, an unidentified number of spills over 30 years, can't, in our submission, relieve it of its obligation to plead that case with sufficient specificity, not least so that the defendant can answer it. Because how can we answer a claim without knowing what regime we're fighting it under? Or when did it occur? How are we to show, well, did we protect an asset in a particular location at a particular time when we don't know what asset or where? I mean, one of the pleadings is we didn't act on intelligence given to us about likely attacks. Well, how can we possibly answer that without knowing which bit of the infrastructure is said to have been attacked and when? And so those are the essential facts of an oil spill. They're an essential fact of one oil spill, and they are the essential facts if one chooses to combine 95 causes of action into one claim.
Well,
And
it's actually, if you choose to include thousands of causes of action.
of course, for separate claimants as well.
Separate claim, because each, unless two people share exactly the same interest,
Yes.
the same spill is going to cause, well, the claimant's case would be many people to suffer damage.
Indeed. And of course, one thinks from a limitation perspective, the time bar for each of those causes of action is different, because a claimant who happens to be further away from the spill will find the time bar kicking in later.
Because it's not monolithic.
It's not monolithic. And this is part of the problem with the global claim, obviously, we'll come back to, is the attempt to make it monolithic. But it isn't monolithic. An individual could bring a claim for a spill, and they would have to plead the essential facts of it. The fact that multiple claimants have chosen to bring a claim for multiple spills doesn't change what are the essential facts.
And that can be overstated a bit, can't it? Because if many of the claimants live in the same town and fish in the same areas, they're all going to be affected by the same spills.
Of course. And that's the point we make in reality about how one would plead causation in this case. That one is going to group people and say the people who live in this area or the people who fish in this area are caused harm by a particular route. So, and that's of course a question of how one pleads the essential facts in a common sense way. But it doesn't change what the essential facts are.
It goes beyond that, doesn't it? Because if you've got a village which has been affected, then that's a classic example where you take one case as a lead case for the village, which you would hope would dispose of a number of cases and give guidance on others.
Potentially, I'm wary of sort of trespassing into the global claim.
Yes,
of course, one has 50.
Not being so wary. But,
But
it is all interlinked.
It is interlinked. But the essential facts in my submission cannot change. What essential facts, as a matter of abstraction, legal principle, what essential facts constitute a cause of action cannot change because of how many claimants are bringing claims. It just can't. That's not a relevant factor to what are the essential constituent facts of a cause of action, or how many spills one's complaining about.
Well then, then you come to the nub of these appeals is it a sufficient pleading of a cause of action to say we reserve our right to say more?
And that's the
crunch.
And that is the crunch point. That is the critical point. And I'm sorry I've taken a while to get there, but that is in a sense what the issue is. Just before I turn to that, I do want to come to the pleading because that really is what the issue is. Can I just do two quick points? One is I just want to show you a chart that's in Supplemental Bundle 3, tab 62, page 896. So this is just to give you a sense of what the amendments have done. The top half of the page is the position pre-amendment with the 10 spills shown in red dots, and the yellow, I'm not sure how one describes that shape, trapezoid of some sort, is the boundary of Bille as defined in the claimant's community claim.
Sorry, I haven't picked this up. Top right.
Sorry, the top left, the big 2015, it's marked in the top left.
Yes.
So that is a chart of the spills pre-amendment, so as the pleading stood in 2015. And if you look about very much towards the middle of that chart, you will see the word Bille, which is actually Bille Town. And then you'll see some red dots. So there's one just to the south of Bille Town, that was a pleaded spill. And you'll see a large number of spills, 8 of them, to the southwest of Bille Town.
Is that 8? You've got one on the other side of the river.
If you've got one that might be said to be an outlier.
3, 4, 5. You've got obviously 5, but the other 5 concealed within the blob.
It's 9 within the cuboid or whatever that shape is. Can't be a cuboid.
We've 2023, a lot more blobs.
A lot more
wider area.
A lot more blobs, and that's really the point I'm just trying to illustrate. Firstly, it's obviously a lot more blobs, but also do note that one is now looking at blobs which are, if I can put it this way, east of the river. If you see the word Yellow Island towards the bottom right of the map.
Yes.
So you've now got spills, which are a lot of spills, which are just above where it says Yellow Island. That is the Cawthorne Channel field, which has its own wells. There's about 50 wells on Cawthorne Island, obviously to the east of a major north-south river. And there were no spills previously pleaded in that field at all. So we've now extended the claim on the face of the pleading into whole new fields that were not previously pleaded. Similarly, if you go to the very west of this chart, you will see there are 10 spills to the west of a river. That is the Alame field. And again, with 30 of its own wells, it's a whole different field. And so you've now got spills pleaded in whole different fields which were not previously mentioned in the original pleadings, but are said to have been matters in respect of which claims had been brought in the original pleadings.
Is there another map which superimposes the location of the claimants?
I'm sure we can produce one. There isn't one.
Well, don't do it specially, but I would have expected someone to have done it.
The vast majority of the claimants live in Bille Town. I think something like 97% live in Bille Town, but they fish. And there are charts showing the fishing locations. They fish in and around Bille Town, but also to some extent in the rivers just to the east and west of Bille. So, in terms of where they reside, almost all of them are in Bille Town.
Yes. What one really wants to know, I suppose, in an ideal world, which we haven't got, is where they say they've suffered damage.
Yes, there are some images that may help you with that. There is a chart that shows some of the main fishing areas, which is one of the two. The main causes of damage are said to be damages to their homes and damages to their fishing enterprises. If you have the unagreed bundle,
Yes.
Which is now agreed.
sorry,
Which is now agreed.
which is now agreed. The agreed unagreed bundle, or the tab 4,
Yes.
page 25. This is a chart produced by the Claimants. And you can marry this up because obviously the yellow, I'm going to call it a trapezoid. I'm sorry to any mathematicians if that's not the right term. But you can see the yellow trapezoid on that matches to the orangish trapezoid on the chart we were just looking at. So this is very much zoomed in on that centre area of Bille. And this shows the 12 most common fishing areas, all of which you can see are essentially near Bille town, or at the most in the river immediately to the west of Bille town. So we've massively expanded the area of spills, and this is one of our complaints on global claims, that hasn't really been a lot of thought given to this, because lots of spills have now been pleaded without any thought of, realistically, how has oil crossed 2 rivers to get to the claimants. But that gives you some sense, I hope, that the loss is very much focused in that core area of the Bille community, but the spills are now pleaded tens of miles outside Bille.
And these red spills, just to understand it, are the location where the oil was spilled from the Shell equipment, pipeline or other
Yes.
equipment. It doesn't show where the illegal refineries were or where waste products were dumped by illegal refineries.
It doesn't, because there's no pleading of that. There's no pleading of locations of what illegal refineries where releases
Well, it's
took
your
place.
pleading that the greater part of the damage was caused by
It is,
refineries, which were all over the place.
And now the claimant's pleading that they will hold us liable for releases from illegal refineries. So now that's the illegal refining amendment, that they wish to hold us
Yes.
liable for that.
Yes. No, I was just thinking that you might have wanted to prove, or to show a map that all these places where the claimants are saying that they couldn't fish anymore were right next door to the illegal refineries.
One imagines that may well be something evident.
No, we don't have that at the moment.
We don't have that at the moment.
And the sort of scale we're looking at, the total, the distance on the Bille spills map from
Yes.
one side to the other is about 25 miles, something like that.
I think a little bit more than that. We've worked out that the area of the orange oblong is about 150 kilometres square, and the area of the purple shape, which captures all of the spills, is about 500 kilometres square.
Is that on page 896?
On page 896.
Okay, hold on.
But I can give you a more precise measurement, but I suspect tip to tip it may be something like 40 kilometres. Well, the second point I just wanted to make by way of introduction to the pleadings is, of course, that the spills that are now pleaded are ones that have come from the SPDC website and from the NOSDRA, that's the Nigerian regulator's website. These are not spills that have emerged on disclosure, have been concealed and now identified. These are spills which are publicly reported, and therefore the details of each of these spills, what is said to have caused it, where it took place, when it took place, all come from reports contemporaneously made by Shell. And the claimants have never explained why they didn't plead these spills originally. They've never explained why they chose the 10 they did. They've never put forward evidence that these spills could not have been found simply by looking at the Shell website and the NOSRA website. Conversely, Mr. Boyne, on the defendant's side, has put in evidence. Of course, it's difficult to show historically what was on a website, but he has been able to show, and I'll just take an example, that of the 49 spills that are now pleaded in reliance on the Shell website, 31 of those, which predate the 21st of October 2012, were already on Shell's website as of that date, as of 21st of October 2012. And that is all the spills which predate the 21st of October 2012. And the reason he's been able to do that is that someone took a download of the spills that have been publicly reported on Shell's website as at the 21st of October 2012 and has uploaded that on the web so one can check, one knows that they were publicly reported.
That's in your skeleton. Have you got the reference?
I will find a reference to that. So the reference to the evidence is, there's evidence in Mr. Boyne's witness statement. I'll just give you the reference to that. It's Supplemental Bundle 2, tab 26, page 531. And then in the unagreed bundle, we've actually produced a table showing where these spills could be found. That's unagreed bundle, tab 7, page 93. And it may be of some significance to this extent. My learned friend can't say that these fall within the definition of, or at least many of them, she can't say, fall within the definition of unpublished spills in the reply, because they don't. They're on Shell's website, and they were on Shell's website, demonstrably.
Just going back to page 896 and
Yes.
trying to work out what it doesn't show us. The legend says that there are different colours for flow lines, Shell, pipelines, oil Shell, and pipelines third party.
Yes.
I'm afraid that the colours are not sufficiently distinct for me to be able to work out which is which. But which of the flow lines third party flowing through this map, which might have nothing to do with Shell?
So if you look to the west of Bille, do you see that there's a red and a green line running in parallel for a distance that then forks? The top of those two is a red third-party pipeline, and so that runs then up to the north. And if you look on the east of Bille, running through the wider river to the left of Yellow Island, you'll see there's a red third-party pipeline running north-south. That starts at 505,000 on the x-axis and then runs north. And so there are undoubtedly third-party pipelines that are closer to Bille than many of the spills now being relied upon.
And nobody's pleaded anything either way about whether they were equally vulnerable to...
We have pleaded that there were spills from third-party pipelines.
Right. But
and we've referred to the fact that there are published spills.
okay. Thank you very much.
So, my lords, then can I turn to the statements of case? So they are in Core Bundle 1. And there are obviously a number of them, but I was going to use the one starting at tab 26, which is the first particulars of claim in the bundle. Starting page 396. So these are the Bille individual particulars of claim, and these are in the form that they were before Mrs. Justice May. So it's the green amendments, which are the ones that permission has been given for. And you see at paragraph 1 there's a summary of the claim. This is obviously only intended to be a very high-level summary. Claimants seek damages as a result of serious and ongoing pollution and environmental damage caused by oil spills emanating from the defendants' oil pipelines and associated infrastructure in and around Bille Kingdom in Nigeria. Now, that's obviously not seeking to define the ambit of the claim, not least because it doesn't apply dates. It's simply a very high-level summary of what the claim is about. Although one will note, I do ask your lordships to note, that it talks about oil spills emanating from the pipeline. That's certainly no reference to illegal refining. The detail of the claim obviously comes later. In particular, page 401. There is an important definition of Bille pipelines and infrastructure. That being, before amendment, the pipelines and infrastructure in Bille, now sought to extend it to in and around Bille. And you note...
But that's consistent with paragraph 1.
It is consistent with paragraph 1, but as I say, paragraph 1 is the very high-level summary of the claim, without dates, without really any particularisation. When one wants to know what is actually being claimed, in my submission, one looks at the detail, the precise definitions, not the extremely high-level summary. And, my lords, I'd ask you to note that the particular fields referred to are Awoba and Krakama, and not, as is now put in issue, places like Cawthorne Channel and Ekalama. But we are apparently meant to have known that the claim extended so far as Cawthorne Channel and Ekalama at the far east and far west of the chart that I've been showing you. Paragraph 17.
There's no definition, is there, of Bille Kingdom? So that one could look at a map and define it? Is there?
The Bille is in fact a defined term, but only in a sense self-referentially at paragraph 3 as Bille Kingdom.
Yes, exactly.
But there was a definition given of the land owned by the Bille community in the Bille community claim, and that shape that we've been looking at is the ambit of the Bille community land as defined in the community claim. But in a sense, that is a matter of definition. One would be able to say, well, what is the Bille community? It might be a matter of evidence, ultimately, what the ambit of the Bille community is. Paragraph 18 then defines these two types of asset, pipelines and non-pipelines. And again, you will see that pipelines was originally defined by reference to pipelines that traverse Bille, now traverse or pass close to. And non-pipelines were defined as equipment, etc., situated in, now expanded to in and or around. Then if you turn, please...
Forgive me, where's the Nembe Creek trunk line?
So the Nembe Creek trunk line, you have that chart again. It's the long trunk, the long pipeline that runs east-west, straight across Bille. So it's the green line that traverses straight across Bille is the Nembe Creek trunk line. Then if you turn on, please, to paragraph 23 on page 403, you will see the definition of, and then this is a critical definition, the 2011 to 2013 spills. So this is a series of spills from the Bille pipelines and infrastructure. So a few points to make about that. First, because it refers to the Bille pipelines and infrastructure, that did originally refer to the pipelines and infrastructure in Bille, now sought to be expanded to in and around Bille. Second, it is emphatically about spills from the pipelines.
Which paragraph are you in?
Paragraph 23.
Thank you.
It emphatically spills from the pipeline, so not illegal refining, not oil that's been carried away and discharged elsewhere. And finally, the word series of spills obviously is one on which my learned friends place particular reliance. But in our submission, that really just begs the question, well, which spills? 10 spills is a series of spills. So which spills does that refer to? It certainly doesn't identify the essential facts of any particular spill, nor does it even say in terms that it's intended to cover all spills from the Bille pipelines and infrastructure in that period. Paragraph 24 then pleads causation, such as it is, and that's obviously the focus of the global claim, that simply you have a general pleading of the effect of the 2011 to 2013 spills. So nothing in there tells you what spills are being talked about. Paragraph 25 on page 405, you have, in support of the averment above, the claimants will rely inter alia on the following facts and matters. And so finally you actually get to the facts that are being relied upon. I'll deal with the inter alia words later, but our short point on inter alia is inter alia doesn't mean you've pleaded something you haven't pleaded. You've either pleaded a fact or you haven't pleaded a fact. Simply adding inter alia doesn't mean you've pleaded facts that you haven't pleaded. Paragraph A says nothing about spills. It pleads some evidence, detailed satellite imagery, and then very large areas of damage. That's probably a particular in support of paragraph 24, which is damage. Certainly it doesn't tell you anything about spills. And then finally, at paragraphs B and C, you get the 10 spills, the basis on which was selected, the basis for which, the selection of which is unexplained, but that pleads 10 spills, some from Shell's website, SPDC's website, some from the Nigerian regulator's website. That's B, C, and D. And that's it. Those were the facts of the spills pleaded. What is then sought to be added at E is a whole raft of other spills. And you see there's now a cross-reference to Annex 1. And if you turn to the next tab, tab 27, page 470, you get page after page after page of spills that are pleaded. And these are the 85 additional spills that are now pleaded. And I hope this is an answer to my Lord Justice Nails's question. The claimants have pleaded each spill, when it occurred, where it occurred, why it occurred, or at least the reported cause, and the spill volume. And one can see, even from looking at page 470, how different every spill is. The first is said to have been caused by third-party interference, the second, corrosion, the third, operational failure, the fourth, human error. Some spills are small. The first spill is only reported to be 2 barrels. Some spills are very large, or relatively large, 150 barrels for the second spill. But each spill is markedly different in terms of when it happened, where it happened, how it happened, and what possible damage it could have caused.
Is it common ground that effectively the information in Annex 1 was in the public domain and available at the time of the original particulars?
I don't understand that to be common ground.
You are asserting.
We assert it on the basis of our evidence.
Is there any evidence that it is? I mean, how are we meant to proceed?
No, in my submission, there is no evidence from the. There is evidence from the defendant.
Mr. Boyne says there's no explanation for the late introduction.
There is, and he positively demonstrates that some of them were on the SPDC website.
That's the 31 out of 49.
That's the 31, and then there's a separate 37, which includes the 31. So there's 30 odd for which there is positive evidence that they were always on Shell's website, SPDC's website. And Mr. Boyne says NOSDRA published the spills that we report to them. There's no reason why they wouldn't have been on NOSDRA's website as they are today. And there has never been any evidence from the claimants to say, we looked, well, my own friend will show you if there is.
No.
But the claimants, there was some evidence which then had to be withdrawn because it was accepted that it was wrong. The claimants have not said they looked on NOSDRA's website and they weren't there in 2015.
And just to take this one further, there's nothing in the way of suggesting that expert evidence was required on causation, for example, before these could be relied upon. And as far as I'm aware so far, but please correct me if I'm wrong, there is in fact no exchanged or published expert evidence one way or the other.
My lord, that's correct on both points.
And that applies to you as well. You haven't yet put into circulation expert evidence about whether or not any of these could or could not have caused damage.
We haven't, obviously in part because there's still a debate about whether they ought to be in the pleading at all.
Yeah.
But one of our points is it seems very unlikely that some of these could possibly have been causative. That there are some very small spills very far away from Bille.
Yeah, but we can't
But
deal with that.
There's no evidence of that. But certainly the claimants aren't saying, well, we couldn't plead these earlier because we were still investigating whether they in fact were causative, because they haven't done that.
How, on your submission, do we understand the pleadings of the third-party interference and the quantities said to have been spilled? It seems to me there are two possibilities. One is that this was spillage in the course of the illegal bunkering. That's to say, they're drilling a hole into the pipeline or whatever it is they do, and some oil is spilled in that way before they can make off with whatever the proceeds of the theft are.
Yes.
Another is that they are were downstream after the illegal refining takes place when they dump the waste products.
So they are never the latter. Because these are Shell's, SPDC's own reports to NOSDRA, they are simply reporting the spill from the pipeline. So oil that either has spilled in the way my lord describes, in the course of stealing it, some oil spills onto the ground, or TPI can also cover sabotage, where there's no intention to steal any oil at all, but simply the pipeline is being attacked in the hope of causing a spillage.
So if we take the quantities, some of them pretty small, but others later are much larger, is that the quantity of oil lost from the Shell pipeline, or the quantity of oil spilled on the ground at the pipeline location?
It's the amount spilled on the ground. And if one looks at the JOVs, it's shown how it's calculated, and it's essentially done by looking at how much oil is around.
So there will be further quantities, as yet unpleaded, which were carried away to the illegal refinery.
If these were cases of theft.
If they, well, yes.
Yes.
But that's what TPI is, isn't it?
Well, it can be sabotage. There are some purely, I want to use terrorist loosely, but purely activities designed to disrupt the activities of oil producers. No intention of taking the oil.
Right. Okay, thank you.
And you said, going back to the question of what was publicly available, you say your evidence is that all this, or most of it, was available on public websites in 2012, and there's been no explanation from the other side, so they must simply have stupidly not read the website properly.
Yes, Lord. And that fits with, frankly, the description of the laissez-faire attitude to pleading in the Supreme Court. What was done here was just, being blunt, a desire to get a claim off the ground, which got jurisdiction, without any proper focus, we submit, on actually what the spills were or how they might have caused loss, which is why one doesn't see illegal refining. What else is the explanation for not pleading illegal refining? Everyone knows, reported everywhere, that illegal refining is catastrophic in the Niger Delta. But they chose to plead a claim simply restricted to spills from the pipeline.
On your submission, it doesn't matter, because it's come in 17.4.
Yes. Yes. But in terms of why it wasn't originally pleaded, I mean, illegal refining undoubtedly could have been pleaded from the very outset.
I mean,
it just wasn't.
I don't really want to pick up on what my lord said, but given the firepower that the claimants have had available, both in terms of solicitors and counsel throughout, I wouldn't necessarily make an assumption that the failure to look at these things was stupid?
Well, I don't, and
we don't have
stupid
any
is not a word I would use. All I can say is the evidence is that they were available, at least a very significant number.
And they were not adopted.
And they were not adopted. Now, whether that was a conscious strategic choice, I don't know. It seems, particularly on a legal refining, it would have been a bizarre tactical choice. And so I can only infer that it wasn't as carefully thought through as it ought to have been. And that obviously does resonate with what the Supreme Court's criticism of the attitude to the pleadings. But in a sense, it doesn't matter. The point is, they didn't plead it, and to the extent it matters, they could have pleaded it. Certainly a very large number of these spills. My Lord, then what's not pleaded in paragraph 25 is any inferential case. I mean, very often one would plead, well, in this sort of case, well, we know that there is mangrove damage in a particular area which started on a particular date, and we therefore infer there must have been a spill in that area at around that time.
That needs expert evidence. You couldn't plead that just off your bat.
Of course you couldn't. But we know the claimants could do that, and we'll look at this in the context of the global claims, because they have access to publicly available satellite imagery, and they themselves have pointed to some satellite images where they say if you look at that satellite image, you can see damage near the pipeline that doesn't correlate to a reported spill. So yes, it needs expert input. It doesn't need permission for expert reports. It needs experts to look at satellite imagery. And
you need a level of expert. If you're going to have an inferential case, you need a level of expert evidence before you can properly plead something.
Absolutely. That's
what I'm driving at.
Yes.
And I mean, this is not the place to start going behind privilege and so on and so forth and asking claimants what expert evidence they've got. But
no, but it was an option available to them. That's all I need to say, that if they'd wanted to plead an inferential case, I'm not saying, one of the arguments ranged against me is, oh, well, we couldn't plead it, and therefore you have to find a way of getting us around the limitation difficulties. I say that's wrong as a matter of principle. Absent a concealment case, which triggers the sorts of provisions one gets in limitation acts around concealment, that's not a relevant argument. But even if it were, there are ways of doing it, extrapolation, inference, but they chose not to. They just did not plead anything about other spills. Indeed, there's not even, in my submission, a positive pleading that there were other spills. When one gets onto paragraph 26, you get the methodology for identifying, assessing and measuring volume and frequency is unreliable. Well, if something's unreliable, it might produce the right result, it might produce the wrong result. That's not a positive pleading that there were, in fact, other spills, and then particulars are given of that. And then paragraph 27, not a positive case that there are other spills, the claimants reserve their position. And as I'll come to, reservations of position have no impact at all because they're not pleadings of facts. Paragraph 28, they can't plead the exact number of spills. Again, could mean 10 is right, could mean 10 is wrong. Not a positive pleading that there were more than 10 spills, let alone the pleading of facts which support an inference that there were additional spills. So we say when you look at this pleading, for whatever reason, and I don't suggest it's necessary for the court to make a finding as to why, but they plead the facts of 10 spills. They don't plead even a positive case that there were, in fact, additional spills. Still less do they plead any case by extrapolation or inference as to when or where those spills occurred. The most they've pleaded is, because your reporting is unreliable, there might be other spills and we reserve our position. And a reservation of position as to what might possibly be an issue later is not the pleading of essential facts. Doesn't allow us to know what case we have to meet, doesn't allow the case to manage it, serves none of the purposes of pleadings. And when one looks at the facts that are pleaded, there are simply not facts to support anything more than the 10 spills that are pleaded.
What's the point then of paragraph 28?
Well, my lord, I would say paragraph 28 is a complete completely pointless bit of pleading, because one shouldn't be pleading in a pleading things that are not facts. And simply pleading that you don't know things is not a fact that goes to any cause of action. It's the sort of thing.
Suppose that paragraph 28 had read that claimants believe there are about 100 other spills, but you've got all the information, we haven't got any, and so at the moment we can't specify. Would that have made any difference to the limitation point?
So my primary position would be no, because it still does not plead the essential facts of those spills. But my fallback position is it would at least plead the fact that there were, by extrapolation or inference, that there were additional spills. And that I can see how one could at least start the argument if one had that in the pleading. That is not what one has here.
Well, and also in the context of a case like this, if you pleaded something along the lines that my Lord has just suggested, it would come through the post on the same day as the application for specific disclosure, or it should do.
Of course.
Otherwise, you're wasting time.
Yes. Well, inevitably. But it's just not the way it's been done. And again, I don't speculate as to why, but that is not the case they've pleaded. And when I say the case they've pleaded, the facts they've pleaded. You can, of course, and I'll come to this in the context of the judgment, you can say that they contemplated claims for other spills. Of course you can say they contemplated them. But that's not the facts they've pleaded. Just while I'm showing your lordships the pleadings, I should just show you the way liability is pleaded, just so you know, particularly going into global claims, how this works. Going on to page 435, I'll use the second defendant as an example.
How many?
435.
Thank you.
So you first start with a pleading about pipelines. So 83, 84, 85 are liability under the OPA, the Oil Pipelines Act. Some of that is said to be strict liability, and 85, you get what I describe as the alternative pleading, which is if it's the results of a criminal act of a third party, then the claimants will aver that we are liable under section 11.5b due to a failure to protect, maintain, or repair the pipelines. And then what you essentially get, if you just look at the headlines of the particulars, A is essentially a failure to design the pipelines properly, B, a failure to have proper pipeline surveillance, on page 437, C, failure to have proper monitoring, D, on page 438, failings in security because we relied on the Nigerian army and we failed to remove people from the Nigerian army, however we might have done that. E, that our employees colluded in the activities. F, failure to repair. And G, failure to clean. Failure generally to deal with TPI. And H, over the page at 439, failure to remediate. So what one has is not a joined up pleading of here's a spill, this is why it's happened, this is why you're liable. What you have is a pleading of here's a menu of ways in which you could theoretically be liable for any given spill. Do
you want to take us to the relevant equivalent passage in relation to the first defendant?
Yes, so the equivalent...
Just to give us the reference, if nothing else.
Yes, so in relation to the first defendant, you get the duty pleaded, because of course it's a common law duty, at page 66, page 419, paragraph 66. And so this now doesn't distinguish between pipelines and non-pipelines, because the claimant's case is that they are, because the first defendant's not the operator, they're not subject to the statute at all. So page 419, paragraph 66. I'll make this point now. It was pleaded that we had a duty to take all reasonable steps to ensure that there was not foreseeable damage as a result of spills from the pipelines. That, I would say, is what my Lord Justice Mayles was describing as the oil leaking as a result of the theft occurring. And what's now sought to do is to extend that to ensuring, take reasonable steps to ensure that claimants didn't suffer foreseeable damage as a result of oil being abstracted from the pipelines and subsequently illegally refined elsewhere. So I'll come back to this obviously in the context of illegal refining, but we say there's no doubt that that is an extension of the duty. So that's the duty. One then has lots of...
sorry, I'm so sorry to interrupt you, but their submission was in to Mr. Justice May was that this all simply went to foreseeability.
Yes, and that's wrong.
But it's a little bit difficult to tie that in at 66.
It's impossible to tie it in with at 66 because it's extending the duty. Otherwise, you wouldn't be amending the duty.
But that's what she accepted.
It is, and therefore, by extension, we say that the judge erred by accepting that submission. And then going the breach, particulars of breach are at paragraph 79 on page 431. And they work in a broadly similar way, but you'll see that there are just general pleadings, for instance, at 79A, that despite being aware of the knowledge of the high risk of TPI, and then that's sought to be extended to knowledge not only of TPI but to illegal refining, we failed to design the pipelines properly, that's I, and failed to ensure that they had adequate spill detection. B is all about surveillance. C is all about detection and shutdown. D is about having unidentified policies, standards and guidelines. E is about compliance with Nigerian law.
And is this said to be the common law of Nigeria, or is it?
It is.
It is.
Although it's fair to say there is no pleading that the Nigerian common law of negligence differs from English law.
No.
And this, of course, covers both, because now we're in a non-OPA world, this covers both operational failings and TPI, because there's no strict liability in the context of the negligence claim. And just to complete the picture for the second defendant, these don't apply for the first defendant, page 441. You have the cause of action in relation to non-pipeline spills from 89A onwards, and some of those are said to be statutory liabilities under different acts. But you also get, page 442, paragraph 91, you have a common law duty to prevent spills or damage from spills from non-pipeline installations. And again, note the extension of that duty to prevent damage as a result of oil abstracted by TPI. So again, an extension of the duty. So 91 is a negligence claim. Over the page at 443, one has a nuisance claim, page paragraph 93. Again, that's sought to extend from what it used to be, oil spilled from the non-pipeline installations to oil spilled after being abstracted. So that's the legal refining. Again, we say that's tantamount to an extension of the duty. We're moving from a classic nuisance duty, one landowner and adjoining landowner, to saying that there is liability and nuisance for things stolen from one's land. And at page 44496, you have a Rylands and Fletcher claim, now rather novelly extended to cover not things simply leaving, hazardous things simply leaving one person's land and going to the other, to now cover strict liability for anything taken from one's land, which then causes damage to someone else's land. And at 98, trespass. And then there are various constitutional law claims which we don't challenge the judge's decision to allow those in. So what you have...
Well, I think they do include the whether from an illegal refinery language, which presumably is part of your challenge on second grounds.
It is in that they incorporate things like the definition of TPI, which we do challenge, because the definition of TPI has now been extended to cover illegal refining. I don't think you
I
actually
was looking, for
see...
example, at the brackets in 98B.
Yes, to that extent, the same point. The illegal refining follows across them, but the constitutional claims per se, we don't.
No, quite.
Because inevitably they do arise out of the same facts. They're just saying on the very same basis you're liable. That also gives rise to a constitutional claim.
The claimants in their sort of identify what they say are the additional claims and the unlawful interference claims. Before we all depart, could you, if my lords agree, could you provide a list that or something that details exactly what you say comes out if your submissions are upheld?
Yes, I'll do that.
Thank you.
So, my lords, I don't, given time, I'm not going to go back over the submission, that each spill is its own cause of action. And one can see that from the way it's pleaded, that one is pleading spills. It's not pleaded in the way my Lord Justice Mayall's posited as a possibility, if I can put it that way, that you simply say all oil must be oil for which Shell is liable, and therefore whatever the source of, wherever it's come from, you are legally liable under one of the following 5 rules. It is pleaded as there are spills, and there is liability for spills. And of course, in many of these causes of action, the spill is essential to the cause of action. You take Rylands and Fletcher, for example. The escape of the noxious substance is the essence of a claim in Rylands and Fletcher. Equally, if one thinks about the cause of action in Section 11(5)(c) of the Oil Pipelines Act, that refers to a leakage or breakage of the pipeline. And so a leakage or breakage of the pipeline is the essence of the cause of action. And so in our submission, each spill is its own cause of action. And that is the way the claimants have presented it, by saying there were spills, you have legal liability for spills.
It's not quite right to say each spill is a cause of action. Each spill gives rise to a spill.
Each spill gives rise to a cause of action, yes. Yes, sorry. Each spill gives rise to a cause of action for the damage caused by that particular spill. And it follows that this is not a case where there is one global cause of action that's been pleaded, and the claimants are just adding some more consequences, some more loss, or just particularising that one global cause of action. They are adding, by pleading the essential facts of additional spills and therefore the essential facts of the causes of action to which those spills give rise, they are pleading additional causes of action. And I said I'd finish on the pleading, but I hadn't. If my lords just go to page 445, please, you will see that there is not a change, paragraph 99, to the loss being claimed. There is a change to what is said to have caused the loss by reason of the matters aforesaid. There's now a reference to the illegal refining. But if you look down at what the actual loss is said to be, that has not changed. There's a correction to a typo, but other than that, the loss is exactly the same. This is not a case of change in loss. This is a case of change of breach. And one can say in a loose sense it's the same duty, in the same way that I have a duty to maintain my car. And if I crash into someone in 2011 because I've not maintained my car, and I crash into someone or someone else in 2013, it can be said to arise from the same duty because I've still not maintained my car. But those are separate breaches. The 2 crashes have different facts, they cause different damage, they occur on different dates. So although they arise out of the same general duty, they are undoubtedly different breaches. And the way I think my own friends try and put it and say, well, look, you just didn't maintain your pipelines properly, or you didn't protect your pipelines properly, is again looking at it at far too high a level. That's not the relevant breach. The breach is allowing oil to be spilled on a particular occasion from a particular place.
Looking at paragraph 99, as you just asked us to do.
Yes.
By reason of the matters aforesaid, the claimants have suffered loss and damage as a consequence of the 2011 to 13 spills, capital S. And
Yes.
that's a defined term which takes us back to paragraph 23.
Yes.
A series of spills from the build
Yes.
lines and infrastructure.
Yes. And I say the only facts pleaded of that series of spills are those that follow in paragraph 25. 25 tells you that it's then going to set out the facts on which they rely. We say the inter alia adds nothing to that, for reasons I'll come to, and therefore the only facts pleaded of that series of spills are those in paragraph 25. My Lords, just while we're doing pleadings, I'll show you very briefly, although I say they are irrelevant, the defence and the reply. Defence is core bundle 2, and indeed I should be clear, I criticise the judge for looking at the defence and the reply in answering the stage 2 exercise. So core bundle 2, tab 34. Page 715.
Is this the defence to the particulars of claim we'd be looking at?
Very much. I apologise, no, it's the defence for the community claim. I don't think we have the defence.
We need to look in bundle 3.
Sorry. I don't think there's any difference in this regard.
All right.
So,
the defence to the particulars we'd be looking at, I think, is tab 44.
it's a slightly later iteration. That's post-amendments.
Is it? Oh, right.
So this is the best one I've got, I'm afraid.
I got rather confused in trying to work these out.
Yeah. Page 715, paragraph 18. So this is the defence as it stood before the amendment. And paragraph 18, we complain about the particularisation of the oil spills. We say they failed to identify the specific oil spills. They've identified 10 oil spills. However, they plead a reservation. Therefore, unclear whether these are the incidents in respect of which the claimants seek damages. We deny we're liable for the instance recorded at paragraph 31, and that's 31, I'm afraid, is the equivalent of paragraph 25, so the 10 spills. For the avoidance of doubt, the defendants only plead to the instance listed at paragraph 31, and that's indeed what we do. So we only plead to the 10 spills. Now, I don't know what my learned friends say they get out of that. We're not saying we accept that they've pleaded every spill under the sun. All we're saying is their pleading is unclear, and we're only going to respond to the 10 spills. There one goes. If you then please go to tab 40, this is the reply, and of course we say, I repeat the submission, not that it will improve it, that claims can't be introduced via the reply. If one goes please to page 943, paragraph 13, the claimants plead the 10 spills are not, second sentence, and do not purport to be an exhaustive list. And then they plead in paragraph A that there are a substantial but unknown number of spills and leakages which are not referred to in the records published by SPDC, the unpublished spills. And on any view, we say that definition does not in fact really engage with the point we're now dealing with.
Forgive me, I slipped. Where were you reading?
Page 943.
Thank you.
13 is the suggestion that the 10 spills are not exhaustive, and the end of paragraph A is where they refer to the unpublished spills. And as I say, we don't accept that these spills in any event would fall within that definition. But in any event, our primary point on the reply is you can't introduce new claims via reply. And that's particularly important in this case, because the replies don't come in until 2022. So long after the particulars of claim had to be pleaded, and it would plainly be a subversion of the limitation Act if one could, by a reply 5 years later, introduce new claims that haven't been pleaded in the particulars of claim. But in any event, I'd say again, this reply fails to plead the facts of any particular spill in any way at all. So, my lord, that's the pleadings. Let me then turn to my submissions, hopefully quite briefly in light of that, on the stage 2 analysis. Really 3 stages to that argument. First, the judge took the wrong approach in how she analysed the case. Second, if the judge had taken the correct approach, she would have concluded that only the essential fact of 10 spills had been pleaded. And third, and perhaps following inexorably, the proposed amendments therefore introduced new causes of action in relation to the 85 spills for which the essential facts were pleaded in the annex to the amendments. So in terms of the principles, I've shown my lord geominerals, and you'll recall that that requires a comparison of the bare minimum essential facts abstracted from the original pleading with the minimum as it would be constituted under the amended pleading. It is simply a comparison of unamended particulars of claim versus amended particulars of claim. One other authority to show you, because it's quite illustrative in this context, is the cooperative group and burst case. That's Authorities Bundle 2.
Is that the floor? Cracks in the floor?
I beg your pardon?
Is burst cracks in the floor?
Yes. Yeah, the concrete slabs, exactly. Yes. Tab 14, page 697. And as my lord says, this was a case where there was originally pleaded defects in concrete slabs, specific design and construction defects, and the amendment was sought to add a systemic design problem that effectively it wouldn't meet the design load. This case has been described in Mullally as the best known authority on what a cause of action is. And if I can ask my lords to go, please, to paragraph 19, which is on page 704. I dare say that what's said in paragraphs 19, 20 and 21 is Hornbook law. Paragraph 19, Wu-Tang and Cooper, a cause of action is a factual situation which entitles a person to a remedy. Paragraph 20, therefore, in looking for a new cause of action, it's the essential factual allegations which must be compared. You ignore unnecessary allegations or further instances of better particulars. And then you get the reference to the bare minimum of essential facts. And that's repeated in paragraph 21. The court is concerned with a comparison of the essential factual elements. Paragraph 22 then tells you how to go about the comparison exercise. First sentence tells you that if a different duty is pleaded, that will usually assert a new cause of action. If you go to the right-hand column, about 10 lines down, there's discussion by reference to something Lord Justice May said, held in Dinnerman, about what's the position where duty is the same but breach is different. And Lord Justice May offered the guidance that one must look not only to the duty but also to the nature and extent of the breach relied upon, as well as to the nature and extent of the damage complained of, in deciding whether as a matter of degree a new cause of action is sought to be relied on. The question to be resolved is therefore one of fact and degree. For my part, I'm not convinced that one needs to look further than for a change in the essential features of the factual basis relied upon.
Is it really a question of degree? I mean, I know Lord Justice May said it, and in those cases it was always Iddle against Trollope and Coles. Week in, week out, people came in with the same 2 cases. But it's not a question of degree, is it? It's a question of fact, whether you have a new course of action.
I think it's principally a question of evaluative judgment in whether or not the facts relied on to constitute the breach are different. And in my submission, all that Lord Justice Tomlinson is really recognising there is that there may be tweaks that one can make to the breach. I mean, say one pleaded that a car was driving at 50 miles an hour and then amended to say 40 miles an hour. But there may be tweaks one can make to the facts which don't sufficiently change the essential factual basis to constitute a new cause of action. But otherwise, if you're relying on a different fact to establish your breach, it is a different cause of action. Because it's all about the facts. I mean, that's the whole cause of action analysis.
Further down the page, Mr. Justice Jackson is reported as having said, point 2, the claimant alleges a different breach of some previously pleaded duty. It will be a question of fact and degree,
Yes.
whether that constitutes a new claim.
Yes. So to take my example, say you have a claim pleaded for negligent driving. You have a duty to drive carefully. That's, and the original allegation is that the person was speeding at 50 miles an hour. Now, if that's amended to say, actually they were speeding at 40 miles an hour, that's technically a new fact.
Well, the essential fact is that they're driving too fast.
Yeah.
Well, and that's, in my submission, why the degree comes in, that if it really is the same fact, but it's just presented in a slightly different way, or slightly changed, that's still the same fact. But if you change that to say he turned left without putting his indicator on, that's still a breach of the same duty, the duty to drive carefully, drive with reasonable care, but it's plainly, as a matter of degree, a different cause of action. And then subparagraph 3, in my submission, is illustrative of this. Because it says, in the case of a construction project, if the claimant alleges breach of a previously pleaded duty causing damage to a different element of the building, that will generally amount to a new claim. Now, I say by analogy, even if here, what the defendant is saying is, well, you did the same thing, you didn't look after the pipelines properly in a different bit of Bille, because the pipeline fails in a different place, that is a different claim. It's very much the same as breach of a previously pleaded duty, but leading to a problem in a different place. And that is a new claim. And so whatever degree means, something causing a failure or a defect in a different place is a different claim. Now, then if you go on, please, to paragraph 24, and this is the paragraph that I was thinking of earlier but couldn't remember where it was. Lord Justice Tomlinson says the judge directed himself by reference to the appropriate principles but didn't apply them properly. He asked himself, what is the existing claim about? And that, a question which fails to focus on the relevant inquiry, which is about the factual basis relied upon, i.e. pleaded. And then the end of that is the reference that I mentioned earlier, where it said that the highest level of abstraction means no more than one must look at the bare minimum of essential facts. I think that's my Lord Justice Mayles who asked me what highest level of abstraction meant, and that seems to be the answer. Might therefore be said that it's not adding much to the other principles. And then the judge conducts the proper analysis, and at paragraph 26, says cannot agree there's an allegation of a further defect in the slabs, even though it was the same slabs, arising out of design, workmanship, or failure must necessarily be the same cause of action, just because it relates to the same duties. That approach ignores the importance which the judge had earlier recognised of identifying the essential facts upon which reliance is placed. And then paragraph 27, and I'll come back to this later because it's important in the legal refining context, the judge also failed to ask himself whether, as a matter of fact and degree, the further allegations assert a new cause of action. So even if you find, as the judge did, that it was the same duty on a legal refining, she failed to go on, I'll submit, to deal with the question of fact and degree. Then let me take you to the judgment, if I may. Core Bundle 1, tab 4, page 71. Perhaps best that I start at paragraph 70 and just say that the judge set out at paragraphs 101, 102, the pleadings, and she there looks at both the particulars of claim and the reply. Paragraph 103 sets out the terms of the GLO, and I should say this is a GLO concluded after the claims were pleaded. It's not.
I'm very sorry, where are we?
Sorry, I apologise. Paragraph, page 70, Core Bundle 1, tab 4, page 70.
I misheard you, that's my fault. Thank
No,
you.
it's entirely mine. Paragraphs 101 and 102 set out the pleadings, and I note including the reply. Paragraph 103 sets out the terms of the GLO, and the GLO was entered after the particulars of claim were pleaded. So this is not a case where the particulars of claim pick up the GLO issues, if I can put it that way. And then the reasoning, the judge's reasoning really seems to be contained in paragraph 104, which he says, analysing the pleadings and taking account of the GLO, I conclude the further spills identified and included by the proposed amendment fall within the scope of the claims already pleaded. I accept Mr. Hermer's submissions that all parties contemplated claims arising from potentially all spills occurring in the period 2011 to 2013. Now, we say with respect to the judge, there are a number of flaws in that reasoning. And first, analysing the pleadings seems to include the reply. And in my submission, that is wrong, because Geominerals tells you, you compare the amended and the unamended pleading, i.e. the particulars of claim, and you're trying to identify which claims have been pleaded. And the reply cannot tell you which claims have been pleaded. Similarly, we submit the judge was wrong to look at the GLO issue because, again, it cannot tell you what claims are pleaded in the particulars of claim. And then, perhaps more fundamentally, the judge doesn't, although she says analysing the pleadings, doesn't actually identify the facts which she says are pleaded and are sufficiently pleaded to cover the new causes of action. And then she says, all parties contemplated claims arising from potentially all spills. Now, the fact that parties contemplate potential claims is neither here nor there. It's certainly possible to say, in light of the pleadings, including the reply, that we all contemplated that there might be amendments to add additional spills. I don't dispute that for one moment. It was obvious from the particulars of claim that the claimants always had in mind that they might well want to think about further spills. They'd reserved the right to do so, to the extent you can reserve the right. But that tells you nothing about what facts have been pleaded. It's making the same error in my submission as was criticised in the cooperative case, asking too generally what is the claim about, rather than focusing with precision on the question of what facts have been pleaded. And that error runs into paragraph 105. I'll pass over briefly. We disagree with this reasoning, but it doesn't matter too much. That the judge said that they've sufficiently pleaded the in or around point, although, as I say in my submission, actually when one looks at the operative paragraphs of the pleading, where one's detailing what claims are being brought, it is exclusively focused on spills in. Paragraph 106, though, is significant. The judge sets out her conclusion, which follows from what she said. If the original pleadings did cover all spills, then obviously pleading further spills is just particularisation of that case. But the final sentence rather suggests what the judge's incorrect approach to this question. She says, Mr. Hermer made a powerful point when indicating that the amount spilled in the 10 currently particularised spills amounts to little more than water in a regularly sized swimming pool. Clearly, this case has always been about more than that. Now, what the case is about is neither here nor there. That's exactly the point made in cooperative. it's a bad forensic point in any event, because the claimants never accepted that the reported volumes were accurate. They could always have said, actually, these 10 spills were much, much larger than you've reported, which was their case, for instance, in Bodø. And therefore, it might well have ended up being their case that actually the 10 pleaded spills were massive, and therefore they were sufficient to cause the damage that they rely on. We don't know. But more importantly, what this does is indicate that the claim as pleaded may well not have worked, and that therefore the claimants were always going to have to amend because they would need to bring more spills into their claim. But the fact that they needed to do that in order to make the claim work, in order to succeed, because otherwise there just wouldn't be enough oil pleaded, can't tell you what they actually pleaded. It can tell you what it would have been sensible to plead or what they might plead in the future when they get more information, but it can't answer the question that the judge had to answer, which is what facts had actually been pleaded. And the idea that one reverse engineers the facts that have been pleaded from the consequences of pleading those facts, in my submission, can't be right. So, my lords, we say the judge essentially took the wrong approach by not asking what are the facts pleaded and by looking at the wrong documents. And that then moves me into my second submission, which is what should the judge have concluded? And in my submission, the judge should have concluded that when one looks for facts in the particulars of claim, not protestations about difficulty or reservations of rights, but facts that are pleaded, the only facts pleaded are those of the 10 spills. I just want to show, my lords, one authority that I suggest is helpful on this, which is in Authorities Bundle 1, tab 8. Because when and it's page, it starts at page 225. This was a group litigation case about advanced corporation tax, and there was a question about bringing in, it had always been said that it was illegal to charge advanced corporation tax in certain circumstances because it was discriminatory. And the claimants were trying to bring in new claims to say that there was an unlawful demand and that they'd paid on a mistaken basis. And you'll see the point taken at paragraph 130 in the context of the amendments was, well, take a commercial view of the pleadings. That's 4 lines down, we're at the cutting edge of the law, take a commercial view of the pleadings. And he essentially says, look, our basic complaint that we shouldn't have been paying this tax was always pleaded. I think it's Lord Justice Mummery, no, Lord Justice Lloyd, no, sorry, I apologise, it is Lord Justice Mummery, says at paragraph 131, well, it's good sense not to be too pernickety about pleading. The basic requirement that material facts should be pleaded is there for a good reason. The case, other side knows what case they have to meet. So it can respond by admission or denial, therefore defining the issues for decision. Proper pleading is essential for orderly progress and sound determination. Definition of issues has an impact on such matters as disclosure and the evidence to be adduced. In my view, the fact that the nature of the grievance may be obvious to the respondent, or that the respondent can ask for further information, are not normally valid excuses for the claimant's failure to formulate and serve a properly pleaded case setting out the material facts in support of the cause of action. If the pleading has to be amended, it's reasonable that the party who has not complied with well-known pleading requirements should suffer the consequences with regard to matters such as limitation. And we say that approach should illuminate your analysis of the pleadings. It's well known they have to plead the material facts. That requirement is there for a good reason, so that we can engage with pleadings, disclosure, case management. It's no use that we just know the general gist of the grievance. And if someone has to amend to add detail that wasn't there before, they bear the consequences of that. And we say that's exactly what's happened here. Yes, we had a vague sense, a general sense, that they were complaining about our records and about the spills in Bille and Alame, but they didn't plead the material facts of those spills, and therefore they bear the consequences of not having done so. And when one looks at the pleading, it is important to have regard to those purposes, because we can't do any of those things with a simple pleading of there was a series of spills. How can we say, well, we did defend the pipeline properly in that area, or we cleaned up that spill, or we're not liable for that because there's a statutory defence given the circumstances in which it occurred? We can't do any of that if all we're being told is there were lots of spills.
What disclosure, in fact, has taken place?
What
disclosure has taken place?
At the time of the amendments or now?
No.
Now there has been significant disclosure in response to a specific disclosure application that was made for the purposes of obtaining documents with a view to remedying the defect which the court had identified in relation to the pleading of spills and causation. And so there has now been, and we set this out in the skeleton for the global claims, there has now been disclosure of annual pipeline integrity reports, our environmental baseline monitoring, all of our satellite imagery and overflight imagery, so a vast array of documents.
In relation to what? The 10 originally pleaded spills?
No, in relation to any spill that may have occurred in the area. But what the judge was not willing to do was order any disclosure in relation to fault. Are we liable for how those spills occurred? Essentially because you couldn't, until you knew which spills you were talking about, we couldn't possibly identify which documents were relevant to identifying what we could and should have done to prevent the spills. If we don't know about the spill, we can't do anything about it. We can't give disclosure of what we did to prevent it. So, my lords, with taking all of that into consideration, we say if the judge looked at the particulars of claim alone and focused on them with the words of geominerals ringing in her ears, compare the essential facts pleaded in the amended and the unamended pleading, she'd have said you have pleaded the essential facts which would have supported claims for 10 spills originally. You've now pleaded the essential facts which support claims in relation to another 85 spills, and you've therefore introduced an additional 85, you've introduced cause of action in relation to an additional 85 spills. And we submit that that was, although I don't need to go this far, the only conclusion available on a proper reading of the particulars of claim. Now, my friends try and turn that around and say, well, they never confined their claim to the 10 spills. That's the word they use in paragraph 22 of their skeleton. But it doesn't matter whether they confined their case. Claimants tend not to say, I'm only claiming for this and that's all I'll ever claim for. What matters is what facts did they plead. The mere fact that they pleaded that they rely inter alia on particular facts doesn't take them anywhere. Firstly, because the words inter alia don't plead facts. The fact you say, I rely inter alia on the following facts, you've still only pleaded the facts you've pleaded. But also, as a matter of authority, if you have Pleas Authorities Bundle 4, at tab 36, page 1583, judgment of Mr. Justice David Richards, as he then was. Paragraph 123, and I'm sorry if this is just stating a proposition that is obvious, but his lordship said more generally, it's not permissible to use phrases such as, for example, or without prejudice to the generality of the foregoing, and I would say inter alia is simply another word in that category, which is seeking to say, I'm not only relying on the matters I've pleaded. The case is confined to the pleaded allegations and particulars, nor is it helpful or meaningful to include a sentence such as the petitioner reserves his position to add further matters. Whether or not he can add further matters would have to be the subject of an application to amend. So, in my submission, the use of two impermissible pleading devices, a reservation of rights and the words inter alia, have no effect in expanding this pleading to include things that are simply not pleaded. I recognise the risks of any floodgates argument, but when one thinks about the difficulties with this, if my learned friends are right, any competent pleader should plead their case in an open-ended way. Take a construction case. You should plead, this is a claim for a series of failures to design and or construct the building with proper skill and care. The claimants will rely inter alia on the following facts and matters, but reserve the right to add further defects identified in the course of investigation. If my learned friends are right, by the device of using inter alia and pleading a series of failures, one has put in issue every possible claim that could be made. And then any subsequent claim can be introduced by amendment without the need to get through the 17.4 gateway. So if the pleader in cooperative had done that, had pleaded this is a case about a series of failures to design and construct concrete slabs properly, including inter alia for the following reasons, the consequences in the cooperative group would not have followed. Ditto, take a libel case, one of the cases we refer to as Economo, where there were pleadings of 6 publications which said one thing, and the claimant wanted to add a 7th publication that said effectively the same thing, and he was told he couldn't because it was different publication, therefore a different cause of action. If he'd pleaded that case as this is a case for a series of publications, including but not limited to the following, and we reserve our right in relation to other publications that may be discovered, the Economo and De Freitas result would not have followed, because again, every possible publication would have been in play. And that, in my submission, cannot be right. It subverts the purpose of limitation, it subverts the purpose of Rule 17.4, it gives the claimant the right to aggregate themselves, a right to add further claims simply at their whim and without the need to worry about Rule 17.4. And it has the entirely undesirable consequence of rewarding the pleader who pleads a specific and open-ended claim rather than a properly particularised claim. Because the more you actually tie your case to specific facts, the easier it will then be for the defendant to say, oh, well, that's a new claim. You plead a totally open-ended claim, you can smuggle anything in down the road. So, my lord, the conclusion to my second submission is that the claimants only pleaded the essential facts of the 10 spills. That's the only proper way of reading the particulars of claim, having regard to the facts pleaded and the essential purpose of pleadings and limitation. And that then takes me to my third point, which I can deal with very briefly before lunch, which is that the addition of further spills does therefore involve the addition of new causes of action. In a sense, that follows from what I've said, in that if I'm right, that it's only pleaded the facts of the 10, and that one has to plead the fact of the spill, then adding the facts of 85 spills must include 85 further causes. I apologise, not 85 further causes of action in relation to 85 spills, there being thousands of causes of action of the individual claimants. And it can't realistically be said, as my learned friends do, that it's just further instances of an existing claim, because a spill in 2013 in East Bille is not a further instance of a spill in 2011 in West Bille, and those are different claims. I've referred your lordships to geominerals as to how one identifies a new cause of action. Essentially, if there is a new breach or a new duty, it's likely to be a new cause of action. And I showed your lordships the cooperative group, where I say, again, it supports the view that new breaches are likely to constitute further causes of action, particularly if they lead to defects or incidents in different places to the previously pleaded incidents. And so we say that applying those principles, geominerals and cooperative group, the claimants are relying on the same general duties, but they are relying on completely different breaches in the same way as my perhaps inapposite analogy with a duty to maintain a car. if you don't maintain a car between 2011 and 2013, and you have two separate accidents in 2011 and 2013, they are different breaches. You can't simply say, well, that's the same duty, same breach, but it's just different loss because two different people have been injured. They are plainly two different causes of action, not least because, and this applies in our case as well, it's not a once and for all breach in 2011. If you know you've got problems with the pipeline in 2011, you may well say, well, you could do different things to prevent a leak in 2013. And so it's not the breach is necessarily has to be looked at not only location specific, but time specific, because how things look and technology will all change over time. So breach is not a single big bang, if I can put it that way. Each spill is a separate breach. So, my lords, we say, for all of those reasons, this was a separate, these were new causes of action involving new breaches. The judge obviously didn't go on to consider fact and degree in the way that in cooperative group, the judge there was also criticised for not going on to look at the question of fact and degree. We say to the extent that one needs to look at fact and degree, plainly, the breaches here have changed massively. This is, on any view, amendments which must cross the line into new causes of action. It's not merely tweaking what was there. The amendments dwarf what was there previously. You previously had 10 spills. There's now a new 85 spills. The reported volumes of the previous spills were 215 barrels. The volume now reported of the additional spills is over 2,000 barrels. The area of the original spills covered around 150 kilometres square. The areas of the new spills cover about 500 kilometres square. So if one is looking at this as a matter of fact and degree, what has been added, as I say, dwarfs what was there previously. And one can't say that's just tinkering or enlarging slightly. It is a radical extension of what was previously pleaded, the 10 spills that were previously pleaded. So, my lord, there's two cases I just need to answer in relation to what my learned friend has said on that. But subject to that, those will be my submissions on the stage 2 analysis of additional spills, if that's a convenient moment.
Right. So we return at 2 o'clock to illegal refining.
I've got to deal with the respondent's notice point on additional spills, but I can take that, I think, quite briefly. And the principles are ones that you're going to have to apply in the context of illegal refining anyway. But I will leave, my lone friend refers to two cases, TJB Trade and Savings Bank and Finken. I'll see what she says about that and deal with those in reply.
Right, 2 o'clock.